This is the Notary Public Basics Training presented by the Office of the New Mexico Secretary of State. To be a notary public, you must be at least 18 years of age, you must reside in the state of New Mexico, read and write the English language, you should not have pled guilty or nolo contendere to a felony or have ever been convicted of a felony, and you should not have had a notary commission revoked in the past 5 years. When you apply to be a notary public, you should first purchase a notary seal or stamp from an office supply store, but not both. An impression of either the seal or the stamp must appear on your application. The application should be completed in black ink only, and the application form can be located on our website. You must also purchase a $10,000 notary public surety bond from a licensed insurance company. The insurance company will provide the bond form, and the bond should also be completed in black ink. On the application, you will obtain the signatures and addresses of 2 New Mexico residents who can attest to your good moral character. You will submit the completed application and bond to our office along with a $20 fee. You'll follow this procedure whether you are a new applicant or if you are renewing your commission. Your term is for 4 years and your jurisdiction is only within the borders of New Mexico. If during your commission your name or address should change, the law requires that you notify our office in writing of this change within 10 days. For a name change, you will complete the form, which can be found on our website. You should include a writer from the insurance company that issued your surety bond that your name was changed on the bond. You will also include an impression of a notary seal or stamp with your current name on it, and the fee for a name change is $3. If your address changes, you may complete the form that is found on our website for an address change. This can be mailed to us or it can be faxed to us. There is no fee for an address change. If you cease to reside in the state of New Mexico, then you shall resign your commission by sending our office a signed notice indicating the effective date of your resignation. You should include with this letter your notary public commission certificate, and you should also indicate that you have destroyed your notary public seal or stamp. If during your notary commission your name or address should change, the law requires that you notify the Secretary of State's office in writing of this change within 10 days. To do a name change, you will submit the form, which can be downloaded on our website. You would need to order a new seal or stamp with your current name on it, and you would also need to include a writer from the insurance company who. This is a sample of the notary public address change and name change forms. The name change form is on your right and the address change form is on your left. A notary public is appointed by the governor of the state of New Mexico. They act as an impartial witness to the signing of important documents and may administer oaths. As a public servant, the notary public's professional responsibility is to serve all people requesting a notarization. A notary shall never refuse to perform a notarial act based on the principals race, age, their gender, religion, sexual orientation, national origin, health or disability, or their status as a client or customer of the notary or the notary's employer. However, a notary public may refuse to perform a notarization if they feel that the signer does not understand the document that they are signing, or if they feel that the signer is not acting of their own free will. A notarization may also be refused if the signer does not have the proper identification, or if the act is prohibited or unlawful. However, a notary public may refuse to perform a notarization when they feel that the signer does not have knowledge of the document that they are signing or do not have. As a notary public, your duties are to take acknowledgments, administer oaths and affirmations, perform jurats, or copy certifications. Although it is not required by law, the Secretary of State's office strongly recommends that you keep a notary public journal. It is a good way to keep a record of all notarizations performed and is a good way to protect yourself as the notary public and your signers. Your journal can be used as evidence in a court of law if necessary. You should safeguard your journal by keeping it in a locked area with your seal. The journal should always be completed before performing a notarization. Remember that your seal and journal are your exclusive property and shall never be surrendered to an employer upon resignation or termination of employment. Pursuant to statute, a notary public may not notarize a signature on a document that does not include notarial certificate wording. A notarial certificate is wording that usually appears at the end of a document. It states what type of notarization is being performed and where the notarization is being performed. These are samples of different notarial certificates. A is for performing an acknowledgement for an individual. B is for performing an acknowledgement for an individual who is acting in their representative capacity, for example, as president of a company. Letter C is for verification upon oath or affirmation, commonly called a jurat. Letter D is for the witnessing of a signature. And letter E is for copy certifications. When performing a notarization, you'll first identify the signer by obtaining from them at least one current document issued by a federal, state, or tribal government agency. This identification must bear an image of the person's face, their signature, and a physical description. A passport is an acceptable form of identification, or the signer may be personally known to you. The second step is to verify that the signer understands the document which they are signing. You want to make sure that they are willing to sign it and that they are competent enough to sign. If there are any blank lines on the document, the signer should first fill them in or draw a line through them. Third, you will examine the document to make sure it includes a notarial certificate. Notarial certificates are usually pre-printed on the document. If one is not provided, you may show your signer the samples in your handbook and have them choose from those which one best fits their document. However, you may not choose the language for your signer. You will complete the venue, which is the state and county where the notarization is being performed. You will need to include the date of notarization in the notarial certificate. If a date is already included, make sure it is the actual date when the notarization is being performed. A certificate should never be post-dated or predated. You will also identify whether you're administering a jurat, an acknowledgement, the witnessing of a signature, or a copy certification. If a notarial certificate is not included and the signer refuses to include one for you, then you may refuse notarization. When completing the notarization, you will sign your name identical to what is on your notary seal or stamp. You will affix your seal or stamp and then enter your complete expiration date. It is improper to affix your seal, signature, and expiration date on any page of a document that does not include a notarial certificate. A notary public may sign the name of a person who is physically unable to sign or make a mark on a document for themselves if the person directs the notary to sign for them in the presence of two impartial witnesses. The notary will sign the person's name in their presence and the presence of the witnesses, then write below the signature, "Signature affixed by notary public in the presence of," the names and addresses of the person and the witnesses. The notary has this authority pursuant to New Mexico statute. The witnesses will also sign their own names beside the signature. A notary public may certify a mark affixed on a document if the mark is affixed in the presence of the notary and two impartial witnesses. The witnesses will sign their own names beside the mark, and the notary would write below the mark, "Mark affixed by," the name of the signer, in the presence of, the names of the witnesses, and undersigned notary public. As a notary, you may charge a maximum fee of $5 per acknowledgement, $5 per jurat, $5 for oaths or affirmations without a signature per person, and for copy certifications you may charge 50 cents per page with a minimum total charge of $5. Your employer may not establish fees for notarial services that exceed the maximum fee allowed by law. However, you may charge less than the maximum fee or completely waive the fee. You may also charge a travel fee if you and your signer agree upon the fee in advance of the travel and you explain to your signer that the travel fee is separate from any other notarial fees. The maximum mileage fee that may be charged is not to exceed 30 cents per mile. Make sure that the signer is before you when you are notarizing a document. The presence of your signer is mandatory. As a notary, you have no authority to practice law or to prepare, complete, or give legal advice concerning documents unless you are also an attorney. You shall not counsel on immigration matters unless you are an attorney or an immigration consultant, and you shall not use the term notario publico in an advertisement, business card, notice, or sign. You should never certify nor authenticate a photograph. A notary may be punished by a fine not exceeding $1,000 or by imprisonment for a period not exceeding 6 months, or both, if they make or give a certificate which they know is false, or if the principal has not signed in the presence of the notary. A notary may be punished by a fine of $500 and shall be removed from office by the governor if the notary performs a notarial act with the knowledge that their commission has expired. The governor may revoke the commission of any notary public who submits an application that contains a false statement if they have pled guilty or nolo contendere to a felony or have been convicted of a felony or misdemeanor arising out of a notarial act performed by the notary, if they engage in the unauthorized practice of law, cease to be a New Mexico resident, or commits a malfeasance in office. The New Mexico Secretary of State is the only office in New Mexico authorized to issue a certification or apostille for a notarized document going to a foreign country. An apostille is a French term for certification, which verifies the authenticity of the notary's signature on the document and that the notary public has been commissioned in New Mexico. A certification of appointment also certifies the commission of a notary public. However, countries which are members of the Hague Convention will receive an apostille, and countries which are not members of the Hague will receive a certification. In order for a document to be authenticated, we require that the notary has signed their name exactly as they were commissioned, that they affixed their seal and signature on the document and included their complete and correct expiration date. We also require that the notarial certificate on the document has been completed. Examples of documents that we receive in our office with requests for authentication are powers of attorney, marriage licenses, divorce decrees, birth certificates, adoption papers, school transcripts, and school diplomas. It is important to remember that a marriage license, divorce decree, or birth certificate should never be notarized or certified by a notary public. These documents will be certified by the office which issues them. Some documents received by our office with a request for authentication are powers of attorney, marriage licenses, divorce decrees, birth certificates, adoption dossiers, school transcripts, and diplomas. It is very important to remember that the notary may never notarize a publicly recordable document such as a marriage license, divorce decree, or birth certificate. This is a sample of a notary public certification. These are used for documents going to countries that are not part of the Hague Convention. This is a sample of a notary public certification used for documents going to countries that are not part of the Hague Convention. This is a sample of an apostille. An apostille is attached to documents which are going to countries that subscribe to the Hague Convention. It is very important to remember the following. A notary must never notarize a signature that has not been signed or acknowledged in their presence. Notaries should never notarize their own signature. A notary should never certify nor authenticate a photograph. A notarization does not prove the truthfulness of the document or make it legal. It only serves to verify that the signer has appeared before the notary public. A notary should not make a photocopy of a publicly recordable document or notarize documents that have been altered with correction tape or fluid. Notaries should also avoid notarizing for family members because their impartiality may be questioned. Should you have any questions that are not of a legal nature, please contact us so that we may assist you. This concludes the presentation of Notary Public Basics. Thank you.